There is a commercial quantity of heroin which yes, your lordship.
Sir, number one,
Number one.
charge-sheeted case.
Charge-sheeted case. Action may be called for.
Yes.
So it is a charge-sheeted case, and it is a commercial quantity of heroin which and total weight is 2272.61 grams.
What is your ground?
And yes, my ground is that kindly answer may be called for.
That is the prayer.
My ground the contraband was not recovered from me. It was I am the driver of the vehicle. I am not the owner of the vehicle, and such contraband was received from secret chamber of the vehicle. There was the number of accused.
What is the name?
And A.S. Pradhani.
Heard Miss K.S. Pradhan. What heard Mr.
DP Gustam.
D.P. Pradhan. In this case, all commercial quantity of contraband. Perusal of the courts of special independence case number 2023. Hence, call for the scanned copy of the aforesaid report registry to issue requisition for registry to take steps for requisitioning the aforesaid scan records. Let this matter be listed again. When 18th of
Bless your lordship.
May please. 482 application, my lord. It's charge-sheeted case.
charge-sheeted case.
Lordship. Number 302 is also there, my lord. And earlier, my lord, who accused or approached this honorable court and the lordship granted.
You are charge-sheeted accused.
Lordship.
Charge sheet has been laid against you. You are named accused in the charge sheet.
In the particulars of the accused, there is no my name, but inside the charge sheet, and one place my name is
the
there.
court has issued summons.
Summons.
You appear before the court.
I will appear, but there is in 302 is there.
No.
So, my lord, the lordship granted bail to the co-accused also, but can we see the page number 97, my lord? Page number 97. That's from the accused approach this honorable court, my
No,
lord.
but at that time, whether charge sheet was laid
Yes, lordship.
when they were granted bail.
Lordship. Page 97, the order.
Now, what are the materials against you?
My lord, with the charge sheet, my lord, I am not in affair name accused person. In the charge sheet, my lord, I have shown as absconder.
Yes, Mr.
Lordship, perspective only. So Lordship, I am humble prayer record to call for a record for the record.
Mr. H. R. Ahmed, H. A. Ahmed, and Abdul Qadir. Petitioner, Dr. D.P. Result of 10 for the next part of PRC case number 1405, along with the 10 copy of case diary of Dr. P.S. case documents that would be necessary for consideration of the case. Hence, call for registry to take steps for executing report that records. Let this case be listed again on 18th of November.
Okay. May it please. Lordship, in this case, the petitioner was arrested on 25/6/2023. Basically, the FIR is at page 21.
25/6/2023.
Lord, 25/6/2023. The FIR is at page 21. I have taken two specific grounds. I'll come to that. The FIR is at page 21. Sorry, page 23 over. I have the honor to report the information was received regarding transportation of narcotics by a team of peddlers who were moving by Toyota Fortuner during Spencer from Guwahati to Hazu, accordingly as directed by Spencer Assam. This team consisting of Spencer led the undersigned immediately chase the vehicle. DOC Hazu PS was directed to set up barricades to stop the speeding, but the vehicle rammed against the police vehicle of Hazu PS. The peddlers tried to escape the Puamokka Hill Road, but after a while, the police team chasing the seizure found his damaged and abandoned at around 150 feet down the hill. One peddler named Franco was apprehended from the nearby hilly jungle while he was been hiding to evade police arrest.
What is your name?
My name is Your Lordship Abul Kalam. This is not the person. Sorry. Dilwar Khan was apprehended, and 1 kg and 24 gram was recovered from the said vehicle. Later, here I am there. Your Lordship. Later, raid was carried out at the rented house of Dilwar Khan at Park Jutis Nagar, Jalukbari, to Manimpuri peddlers, namely Mustaqim and Muhammad Abdul Kalam. This is the petitioner here. Were apprehended along with 65 packets of heroin enclosed in as many soap boxes weighing 765 grams without suitcases found in their possession, which were duly seized. So basically, this is the now my case is on two grounds, Your Lord. Number one, the the challenging the section 52A as well as the 2022 rules of NDPS seizure and disposal rule. They have the sampling was not done correctly. Number one, so during the seizure, and though they have the magistrate certification was issued, but the sampling which is required to be done, weighing each and every 65 boxes here, it has been stated, the 65 boxes have not been weighed. The test, color test has not been done individually. This whole part, Your Lordship, that has not been. They have taken it together and made it I think invent. So that has totally violated these two provisions, which are mandatory. Number one. Number two, Your Lordship, is basically the petitioner is more or less 1 year, 5 months in custody. And Your Lordship, there are 50 witnesses, 50. Out of 50 till today, only 2 witnesses are, Your Lordship, examined. So there is a long incarceration. In fact, this matter will not be completed in a very near short while because 50 witnesses, out of which in 1 year, 5 months, only 2 witnesses have been named. So these are the two grounds. Number, Lordship, I'll take Your Lordship for the first part into the page 26, Your Lordship. because the record will, I think the scan copy.
Just a minute.
আগতেও আপডেট আপডেট নাই আপোনাৰ নেক্সট ডেট আছে সেইটোৱে আছে আপুনি সেইটো তাত নাই কিন্তু আপডেটটো নাই তাৰমানে তাতে আগতে তেনেকে উইটনেছ পাৰ্টটো বাৰু আমি নাজানো মেইনলি 52 এইটো স্কেনটোকে আছে নাই আগতে আছে ইয়াতে পৰিছে ইয়াতে এটা প্ৰথমটো গাড়ীখন এক্সিডেণ্ট হ'ল তাত দুটা মানুহ এটা ধৰিলে So your lordship will turn to page 26. This is the order, your lord.
Page 20.
26 here. From here, I just like to point out that in page 27, this is 26/6/2023 order. Lordship will find in the next page. Here, your lordship, at page 27, second part. Further, seen the prayer made by IO for taking notice of the seizure list and seize exhibit documents, items, so and so, MR, so and so, so and so, so. In our case, MR 15 of 2023 is the case with regard to the 65 soap cases, which were recovered, were alleged to have been recovered from the house where the present petitioner is lost. And this was allowed, your lordship. And in the next paragraph, your lordship will see further also seen prior to allowing the draw representative samples and certify the correctness of the inventory is allowed. So and so a special magistrate is entrusted to draw samples of the seized drug and certify the correctness of the inventory. The prayer of the so and so has been allowed. After this, your lordship, though your lordship, the certificate was issued, it was issued as the as a whole. It has not been issued, your lordship, with regard to how many samples you. The drawing and drawing of the samples as per section 52A, as well as the rules of 2022, the drawing should have been accordingly. First and foremost, your lordship, mostly know that each and every lordship cases has to be weighed and color test would have been done, and then two representative samples in representative samples in duplicate has to be taken. This procedure has not been. That particular procedure has not at all been followed. Even the certificate issued by the magistrate.
Yeah.
And the certificate issued by the magistrate, I think the scan copy will show. There, your lordship, the whole bunch has been taken and it has been certified. Because the specifically the list of the, your lordship, the seized articles, the list is not there. The list has not been certified. Only
Which list?
list of your 65 soap cases which has been recovered. That is not.
Inventory
You can
is not,
see section, sorry,
whether inventory is there or
inventory we have not any. I could not, it is there in the scan copy, it is.
so where there is non-complete. Which part?
The first part, your lordship, number one, that as per the rules of 2023, NDPS seizure and disposal rule, the first part is that the sample has to be taken in duplicate from each cases, boxes. That is one of the rule that I'll refer to the rule. One, number one. Number two, your lordship, the color test before that to show that each and every packet were the same. That is why weight has to be taken and color test has to be.
These are there already in the rules, each one. That has not. Then your lordship, finally the total way is there. Total weight is there. It has been given, but each and every one, whether these representative samples that were done in duplicate from each and every boxes, or sorry, in this case, its packs, have been taken or not. These are not correctly, your lordship. This is basically on the ground, as per the rules, that has to be. What the rule says, your lordship, was first the rule, your lordship, 10(2) of the rules, provided your lordship has got the rules there, 2022 rules.
You given copy.
It is not available. Rule. Actually, I have. No, I got it.
Within 15 days, you know.
No, 15 days to no, rule 2022. Way করবো লাগবে প্রত্যেকটা step.
Every packet
Rules are-
copy.
First, your lordship, the color test has to be done by the drug identification kit, which will conclusively prove that
Now
these
whether,
are identical.
whether this was done or
Not
not,
done.
this will come up in trial.
That is true. It will come up in trial, but these things are done at the beginning, your lordship, before the trial starts. And this report has to be submitted. The-
Now report has been submitted.
No, they have given a certificate. They have given a certificate, but the certificate does not indicate the samples, which says that this much number of amount of heroin has been
So
recovered.
there
from
is
suspect.
a complaint of 52A,
52A,
but not as per the letter in spirit of the
yes,
rules.
of the rules.
So
Your
your
lordship-
submission is that even though there is some effect in, say, drawing the samples or making certification, then you will get benefit in grade.
That is what I'm trying to say. That is what I'm trying to say, because this is a 52A is mandatory, your lordship, when the rules have come from the basis of that particular statute. Now, the statute says when there is a mandatory violation,
No, but on prima facie look at
Yes.
on the record.
Yes.
It appears that 52A was followed, certification was there.
only the certification was there. When the certification is issued, your lordship, what is this certification? Mostly it says that this numbers, these are the samples, and this sample has been certified. Here it is not saying that these are samples. 65 soap cases, this grams, this is certified. That is what I have seen from the your lordship certificate. There are 65 cases, your lordship. The numbering is given 1, 2, 3, 4, 5. It should have been given. Nothing is given. How it will be derived, your lordship, from which, what sample has been drawn, whether it has been drawn or not, it is a homogeneous mixture taken, what, we cannot say, your lordship. That is where the petitioner will be prejudiced in that case, because this is not a case where the petitioner was arrested from the place of occurrence. It was subsequently on the, when the police have raided the house of one of the accused, these persons were found, and from the house, this amount of heroin has been recovered. This is not directly he is in possession. Therefore, and your lordship knows that it has to be very clearly and unscrupulously followed. When these are if there is a violation of the rules, it is also violation of section 52A.
You have
Because
any,
the
you have any,
from the act, your
you have any authority to,
yes, I have
That's
just
what-
gone through a judgment of your lordship today. I was in fact reading in the lunchtime. Your lordship has actually passed a bail order on the basis of the fact that these rules have not been scrupulously.
no, to what extent?
That to the it is a bail order, your lordship, bail order.
No, what was the,
It was not heroin, it was ganja. There
What
on
was
3
not-
grounds your lordship has rejected. Number 1, those packets were not weighed separately as per rule 10(2). And then there is a one ground your lordship is taken is that I think 3 section, sorry, rule 3(2), where it says that where it says that the tests have not been conducted to conclusively prove that each and every packs contains the same materials at the same weights. Exactly, I am making the same submission here. Your Lordship. Here also, your lordship will not find from the records. My learned friend will be in a better position to explain. Here, the whole thing has been taken as one.
No, in the case which you are citing, was there certification? Certification was there. Or
That it was
in this case,
there is a certification in this case, but I don't know whether in this case there is a certificate. Hey, judgment to PM. So that I can just refer to your lordship.
Maybe before lordship, or LCR to receive receipt, it's not up to date. Last date is P6 or next date, because it is gone earlier. That first time column is not on there
না,
last
গোটেইকেইটা
year.
নালাগে, অকল সেইটো।
So my humble prayer for
এই-
receiving
এই
the
কেইখন
updated
গোটেইকেইটা
LCR
confusion হৈ যাব।
on
no, no.
with a rule.
We will decide the matter because here his plea is one
Rules
plea
followed or not,
52A
compliance for
is not followed and the 22 rules are not followed. Second plea is prolonged incarceration. So we do not need any further material. The materials which are available may be sufficient to address these points which we have. Have you gone through the LCR?
the whole part of the case, LCR I have not gone through.
No, the plea which
I've
he has
go-
taken. He has taken the plea
Yes, yes.
that
Taken it in my petition itself.
22 rules are not followed.
That-
Now, to what extent there is a violation of it, whether it entitles him to get bail on those grounds or not. This would be your answer.
Then lordship, I will pray for some accommodation to.
And
on other date. I have to
regarding
book, LCR.
regarding prolonged incarceration, you are still less than 1.5 years,
Less than
so you may not get that many.
Yes,
that is up to your lordship. I won't be. But the question is, there are 50 witnesses.
No, but
In the
You
near future, it may not be possible to complete the trial. Anyway, that is your lordship. I'll come to that later.
so
Only point now, if your lordship says that means 52 and rule of 20.
you make your submission because in this case, I think there are many adjournments.
Mm. Mm.
Yes, you may complete your submission.
So, your lordship, this judgment, your lordship, I think in that judgment, the certificate has been given, though it is not indicated because it was done in the front of the magistrate. Similar in this case, that judgment says that the weight, specific weight, I'll just take the,
Which judgment you are relying?
just I have given just now, Altaf Hussain judgment. This is of 5/8/2024. Here, if your lordship will kindly take up para 21 of your lordship. Observations are from that para.
So your submission is that violation of provision of 2022
Rules,
amounts to violation of
section 52A,
and it will give you benefit
because that
considering
being a mandatory provision.
later. how there is violation in this case?
In this case, your lordship, three specific violations. Number one is that each and every sample has to be drawn in duplicate
Which rule has been violated?
from the 22 rules, your lordship will see.
22 which rule?
22, first, your lordship will take up rule 3. Will come to be at- No, that is the question of the violation of rules.
Or Mr. Goswami, when are you answering?
Lordship, 12 of November. Lordship.
Then we'll hear the matter on 12 instead of,
How was that?
12,
because
eight,
it,
11.
it will otherwise also come to the bench on.
Okay. 12,
Heard Mr. Y. S. Manna, Government Council for the Teacher. Also heard Mr. T.P. Gupta, teacher for who raised for some more time. Go through the scanned copy of the record which are available for the court before you make the fair is allowed.
52, 80
Let this matter be
Mas muna
taken up
natin kung ano po. Sorry. Ano na yan?
12 November 2000.
command tomorrow.
Kapag ko. Mga po. Abbreviation.
12 November.
12 November. Apply. Item 4, Lordship, I have small pair of
Petitioner is absent. None appears for petitioner. Call.
that are not private.
Let this matter be fixed in the next week on a date to be fixed. What was your prayer?
I think I lost it, 5 and 6, 4. 5 and 6, I have small pair.
DP Gupta, Mr.
My lord, item 6 is a part heard matter, my lord. We came for quashing of the, my lord, the order of framing charge as well as, my lord, the whole proceeding. Thereafter, my lord, we filed one, my lord, bail application also, my lord. And, my lord,
How much time will you?
I will not take much time, my lord.
What is your prayer, Mr.
I have not gone for case record. Half part of the case record I have gone for. I have advanced in another court. In a hurry, CPS informed me.
But this matter is part heard matter.
Whatever.
Some
Yeah, my
other-
lord, this petitioner's father, he expired, my lord, day
Friday.
before yesterday. We filed one bail application also, my lord.
In bail application, Lordship, first framed on 19/4/25. What part I have gone for, Lordship, and 12 PWs are there. And 2 independent examine, but other part is not examined yet. Other witnesses.
No expired, then you are in custody.
I was in custody, my lord.
Then who performed the last right?
Their janaja was performed, my lord. That all the details I could not get, my lord.
Now what is your prayer? He has, you are not ready.
I am not ready, Lordship. But
And my lord, either the quashing also lordship has heard regarding the facts, my lord. Only lordship had asked me, my lord, whether 482 application will be maintainable or not.
For discharge.
Because it was order of framing charge. Then lordship pointed out that it should be 397 application, my lord. But we have filed on 482 application. To that effect, my lord, I have found that some of the, my lord, Supreme Court judgment, my lord. Those, in those
If
judgment, my
your
lord,
criminal petition is allowed, you will otherwise get benefit.
my lord.
other side shall have to be heard. We have half an hour time. We can,
Here, my lord, from the position of the accused, my lord, nothing has been
Yes.
recovered. Some article which say, my lord, this contraband articles was sent from my lord Dimapur.
no, let me hear. How much time this RFA will take? Then we don't have time today.
Appellant had argued partially, my lord. That was
Is doctors.
Doctors and the
Yes.
flats.
But today we, I think it may not be, again it will go, we'll fix a date. We'll fix a date or leave it on registry because we
My lord
are,
will kindly fix the date, my lord.
but it is not within our, because even if we fix a date,
My lord.
I am now sitting in division. So that has to be again accommodated. When do you want?
My lord, perhaps
After-
we can try in November, my lord. If it
After-
doesn't reach, my lord, it doesn't reach.
Okay. Suggest a date.
Lord, 12 or 19?
No, after 40.
After 19?
19.
Tuesday.
Mr. Who is appearing for
And Burwa.
third Mr. N. Durga, Learned Counsel for the applicant, and Mr. H.
BT.
Sorry, B.T. Decker, Learned Counsel for Connect. In both 8 and item number 7. Due to paucity of time, this matter could not be taken up for 8. Let this matter be listed again on 19th of November. It is not shown as part of, no?
No, madam, just we started from afresh.
Perhaps it's been treated as part heard because of last quarter.
Okay, it will otherwise also on 19th of
Obliged.
we can hear you, Mr. Chaudhary, on your watching. Then we again have to pick a very short date
My lord.
after hearing, so that he can
Can
inform
give the
Mr.
reply.
Botaku.
Bhattakur.
Botakur was earlier there, my.
I'll inform Botaku. अपना पट कोई जो
Or you want to argue in presence of Mr. Bhattakur?
I can, my lord, only a few points are there, my lord. I can just point out those.
Today?
Yes, my,
Yes, yes. Because
But-
we have time.
my lord. This is a case, my lord, where lordship will find a FIR at case 31, my lord.
Which we are taking a
Uh,
criminal case.
My lord, a criminal petition.
Page 30.
Case 31 is the, my lord, FIR.
Yes,
May I just read it, my lord?
yes.
I have the honor to report you that today, 12th and 2023, I, along with the below detailed Naka checking party, were conducting regular Naka checking at National Highway so-and-so at so-and-so. While executing Naka checking at 2:23 p.m., our Naka checking team detained one white color I-20 vehicle bearing registration number so-and-so, which was coming from Dimapur side towards Golaghat via Borpathor. There were two persons in the vehicle named as Mohammed Saeed Khan and Mohammed Iqbal. They are the co-accused, my lord.
You are Jamaluddin.
I am Jamaluddin.
You were not in the vehicle.
I am not in the vehicle, my lord. Then, my lord, on asking the persons on the vehicle, both of them were nervous and were not able to give any satisfactory reply. about where they were proceeding to and for what purpose. So suspect arose on them, so I approached to local person named so and so, and explained them the matter and asked them to stand as witness during the charge. I also informed SDPO Bokazan, and within a few minutes, SDPO Bokazan along with his staff arrived at the place. After that, the vehicle was searched thoroughly in presence of independent witnesses and recovered 60 numbers of plastic soap boxes containing suspected heroin from a secret chamber on the door panel of the body of the vehicle. The recovered suspected heroin was weighed in one digital weigh machine and found a total weight to be 726.05 grams without plastic soap cases. After that, I marked all the soap cases, serial number so and packed it in one carton and sealed it in presence of witnesses. Accordingly, I seized the below recovered items from the possession of the accused person, Sahid Khan and Muhammad Iqbal. Then, my lord, this is the description of the seized articles. Here, my lord, they have seized one duplicate vehicle of the RC of the my lord vehicle, one driving license of Sahid Khan, my lord, and one duplicate insurance copy and one my lord mobile phone. I apprehended both the accused persons, and after completion of all the formalities, I along with the team departed from the place of occurrence to PS, taking all the seized items and the apprehended accused persons. It may be mentioned that I, being the sub-inspector, empowered by the government of Assam by notification dated so and so under the provision of section 42(1) of the NDPS Act to enter, search, seize and arrest without authorization. I therefore request you to register a case under proper section of law against the apprehended accused person as per law. I also hand over the above mentioned seized item, digital weigh machine, so and so. Then the my lord name of the two persons who were in the vehicle. So my lord, the present petitioner, he was not in the vehicle.
You are not named in the
I am not named in the affair, my lord. Nothing has been recovered from my possession, my lord. And neither I am the my lord registered owner of the vehicle also, my lord. This vehicle has been sent from Dimapur by one person, my lord. He is neither an my lord witness nor an accused, my lord. The person who sent the vehicle.
Now, how you came to the picture?
Be-
How it-
Because, my lord, the person from the Dimapur, my lord, while sending the vehicle through these, my lord, co-accused persons who were arrested, my lord, to whom, my lord, that person told that you deliver these articles to one Jamaluddin of Juria.
So you are the destination.
Yes, by that, my lord, my lord, involvement has come, my lord. And my lord, that person, my lord, who has sent the vehicle and who has told my name, he is neither an, my lord, witness nor an accused in this case, my lord.
Who is that person?
His name does not appear, my lord.
Okay.
His
So
name, my lord,
you says that somebody told us
my
to
lord.
deliver it to Jamaluddin
Yes. That
without naming that somebody.
yes, my lord. That person is neither before the my lord court as a witness or as an accused, my lord. And these two persons, my lord, the co-accused persons, my lord, they do not know me, my lord, because to them it was informed by my lord that person of the Dimapur, my lord.
And now the charge sheet has been laid.
Searches have been laid,
Sir, framed.
charge has also been
The
framed, my
only
lord.
material is the statement of co-accused.
Yes, my lord. That
We
it
have
was told by my lord the another person, not is the statement of the co-accused. Because it was told to the co-accused that you deliver these articles to Jamaluddin of Juria, my lord. And in between, my lord, in the Golaghat district, my lord, this vehicle was apprehended. Whether with, my lord, this much of materials, my lord, whether one can be charged, my lord.
Because though during investigation, Mr. Putnam, you got a lead from the
apprehended person.
apprehended person that it is to be delivered to. But that lead in it itself is not evidence. But you have to collect evidence to incriminate him. But if the IO has done nothing after getting that statement, which was only a lead to how to further the investigation, without, then perhaps their case is strong.
Yeah.
If
This is my case, my lord.
if you are unable to show any other evidence except the statement of Koik,
Lordship.
then because of Tufan Singh's judgment,
Yes.
your case goes.
Lord.
But how will you address that? Why have you come for quashing, not for revision?
My lord, I have got, my lord, some judgment, my
Because
lord.
if revision is allowed,
Yeah,
your case could have ended.
my lord,
If it is allowed in your favor,
my lord.
so revision lies against that law.
Even, my lord, there are some decision, my lord, that 482, whether, my lord, it
Mr. Goswami,
Lordship.
you have to answer on, first you have to answer, is there any other material apart from statement of
The co-accused.
co-accused who have implicated the present victim? If there is anything, you have a case. Then the question of procedure, revision and, yes, what is your submission?
my lord, I had got one decision of my lord, Supreme Court, my lord. 2016, 16 STC, case 30, my lord.
What is this section 200, 2000?
2016, 16 STC, case 30. Prabhu Chawla versus State of Rajasthan and another. This is a, my lord, 3 judges bench, my lord.
What it says?
Here, my lord, it is 482 criminal CRPC, my lord, 482 and 397. Relative scope of reiterated, nothing in CRPC, not even 397, can affect amplitude of inherent powers preserved in so many terms by the language of 482. But inherent powers should not invade areas set apart from specific powers conferred under CRPC. However, there is no total ban on exercise of inherent power where abuse of process of court or other extraordinary situation warrants exercise of inherent jurisdiction. The limitation is self-restraint, nothing more. Availability of alternate remedy of criminal revision under section 397 by itself cannot be a good ground to dismiss an application under section 482 CRPC. Section 397 is attracted against all orders other than interlocutory. A contrary view would limit the availability of inherent power under section 482 only to petty interlocutory orders, which situation is wholly unwarranted and undesirable. That is from, my lord, para 6 to 9, my lord.
No, then where is the limitation? What
Ma-
is the limit?
My lord,
Then what is the limitation? So then it means that in every case you can file either 397 or 480.
my lord,
Suppose if you file a case where revision lies,
my lord,
you file 482.
my lord,
Then if you show this judgment,
my lord,
then it means that you have two options.
my lord.
But on the other hand, this judgment itself speaks that where specific powers are conferred under CRPC,
My lord.
then perhaps you should come under that. Though there is no
Specific, my lord, it is stated that there should be a, my lord, specific bar.
specific power.
Rightly or wrongly, my lord, if I, my lord, file the application under section, my lord, 482 also, my lord. Considering the, my lord, my lord, whatever, my lord, material has collected, my lord, whether, my lord, this is a case, my lord, where the proceeding
No,
can be
the
quashed.
question is in 397, there is a question of limitation.
Yes, my lord. This case is even within limitation, my lord.
Limitation.
Even it is within limitation.
Then it can be converted also to 397.
But
Okay.
my lord, I have got somewhere, my lord, whether my lord 482 application can be converted to 397 or not.
Because 482 is a wider,
Yes, yes. It has got, my lord, wider jurisdiction, my lord. Ample power is there before the Honorable High Court, my lord.
what other judgment is there?
Another is, my lord, there. This is, my lord, Vijay and another, my lord. That is 2017 13 SCC, my lord, page 317. Here is also, my lord, 397 is attracted against all orders
You
other than
have
in,
statement of all the witnesses
my lord.
apart. You have gone through the materials which are provided to you,
My lord.
207.
Yes.
Nobody has stated
Nobody has
anything.
implicated, my lord. And, my lord, they will give the, my lord, reply because they will, what I have gone, my lord, I have not found anything, my lord.
But you have not found anything.
I have not
except
found it. Nothing, I have not found anything, my lord. Two witnesses have already been examined, my lord. They are the independent witnesses, those, my lord, Caesar witnesses,
How many witnesses are there?
12 total. Others are all, my lord, official witnesses during that Naka checking.
In the charge sheet, which witness is going to prove what aspect of the prosecution case? There is an indication.
My lord, these two witnesses, they are the, my lord, the Caesar
Caesar
witnesses.
What are other witnesses are going to prove?
Other
What the other
witnesses are mainly for the, my lord, the involvement of the other two co-accused, my lord, who were found at the place of occurrence. That, my lord, in the vehicle, my lord, in the secret, my lord, side
But
coverage,
they are
there,
also regarding Caesar only.
Caesar only, my lord.
So you have to take this court to each and every witness.
On the next date, my lord.
Yes.
Even I can, my lord.
No,
I
later
have got the copies, my lord.
I got your case. We will fix a short date
My lord,
so that before I forget, we can.
my
proceed.
lord.
His main case is no material except co-accused, and the query regarding 382, 482 and 397 has been what this Vijay case says, 2017,
Yes, my lord. Vijay and another 2017 13 SCC,
what it says.
317, my lord. Here also, my lord, 397 is attracted against all orders other than interlocutory. Such a view would limit availability of inherent powers under section 482 CRPC only to petty interlocutory orders. In view of settled law, mere availability of alternative remedy cannot be a ground to disentitle relief under section 482 CRPC.
More so when your petition is within the period of
My lord, my lord.
had it 482 been filed only to overcome the
Limitation,
effect
my
of
lord.
limitation,
Limit.
then there would have been a different question.
My lord.
But in this case, it is within the period.
Hmm?
We'll take it up on when should we take it?
12-11, another cases, I have taken time for 12-11, same day.
Now instead of 12, we give it.
13, my lord.
left,
1313, my
one,
lord.
three.
My lord.
Mr. B. M. Chaudhary, and counsel for the petition. Authored Mr. P. P. Gupta, petitioner for that. Hearing be made inconclusive. Let this matter be listed again as further matter on 13/11/20.
I'm obliged, lordship.
Hmm.
Good,
Hmm.
good, good.
One item.